Good day, ladies and gentlemen. It's a great privilege to be taking part in this conference of the Parental Alienation Study Group, particularly since the theme of prevention is one which I have been studying and writing about for the last few years. I've been asked to speak about prevention and early intervention and swift court action, how these work in Israel, what Israel has achieved and what challenges we're facing. And I want to start by speaking about the model of prevention that I've developed together with Nick Child and David Curl, from whom you heard, I think, yesterday. It's based on three elements. The first is primary prevention, which includes raising awareness among the general public of the existence of parental alienation and the other reasons why a child may stop having contact with a parent. It involves raising awareness among those professionals who work with children and their parents on a day-to-day basis, so that they will understand what happens to children whose parents get divorced and what might happen if the parents' separation is not done with the interests of the children in mind. The second stage is to alert people, especially parents and those same professionals, to the first signs of distress in a child which may arise from the parents separating and the level of conflict between the parents, and to bring about immediate intervention with the parents and with the child in order to prevent the situation from deteriorating. The third stage is to make sure that courts, if they are faced with a situation in which one parent alleges that the other is interfering with contact, that these cases are dealt with swiftly and efficiently and effectively. And I'm going to speak about the second and third parts, that is, early identification and intervention, and also how court action works in Israel, on the basis of my experience, first as a lawyer and then as a judge, and then since my retirement as a researcher and writer and taking part in programs in these various areas. I want to make it clear that Israel's system is based on social services which are available to the general public, and also a special social services unit which is attached to the courts. I also want to explain that the Israeli judicial system is a common law system based on the adversarial aspect. However, as I've written, elements of what's called therapeutic jurisprudence, or what I prefer to call judicial therapy, are built into the specific family court legislation. One of them is the addition to the court of social workers in the family court social services unit. But there are other aspects in which the court is mandated to act, and does indeed act, in order to take into account not only what the parties want and what they apply for, but also the effect of any process on the parties and those surrounding them, and in the specific cases we're talking about at this conference, their children. The children are not a party to the proceedings unless the court decides that they should be, but they are certainly held very much in mind, both in the processes before the family court social services and when the court comes to determine the issues. We also have a sophisticated system of how the voice of the child is heard, if the child wants to be heard, by the social services of the court. However, after that introduction, I want to go back to the issue of early identification and immediate intervention. I've been working now for the last 4 years or so with an organization in Israel called In Between. The website is called Balev, B-A-L-E-V, and you can look it up. They have a website in English. One of the things we've been doing in this organization in between, which has a professional consultative board of which I am a member, which includes social workers and psychologists and psychiatrists and educators and lawyers and judges and members of other professions who are involved in one way or another in educating and dealing with children whose parents are separating. We have now for some time been approaching or been approached by members of different professions in order to give direction and training. So, for example, I have lectured before nurses, emergency room nurses, so that they will be able to see when a child is admitted if there is tension between the parents and if that is affecting the child, how to call in the social services from the hospital. I've been speaking particularly to teachers and to educational counsellors in order to explain to them what goes on with a child where the parents are separating and divorced, and if there is violence or abuse or shouting in the family, how that might affect the child, and how to see the signs that a child is affected by what's going on at home. This may take various forms. A child who previously excelled is now deteriorating in his achievements. A child who was previously friendly may become solitary. A child who was previously solitary may now be associating with the less able students. A child may be overeating or may not be eating at all. A child may come in proper clothing in the past and now shows up without proper clothing. Child may not do his homework. There are many other signs which can be picked up not only by the teacher but also by the other staff in the school, which indicate that something is going wrong with the child. And we are also helping teachers and parental and educational counsellors how to interview the child in a gentle fashion, and then, if necessary, call in the parents and tell them that it appears that disharmony in the family is causing trouble for the child, and recommending that the parents immediately obtain assistance for themselves in order that they should improve their parenting skills and their parenting together, and also help for the child. We're doing the same thing with social workers. I found it very interesting and useful to speak to students of social work and law and education and medicine in order to educate them as to what they might see and how they might be able to intervene. So that is the first part of early identification. Intervention, of course, has to be carried out by people who are skilled and professional and knowledgeable in the field. I'm sure that this conference will include reference to the damage that can be done by an unskilled or unaware therapist, maybe a psychologist, maybe a social worker, who is not aware of the specific features of a child who is affected by parental strife, and therefore there is a necessity to set up a cadre, a group of properly skilled and trained therapeuticians in order to provide the appropriate intervention for the parents and for the child. This involves many issues. One of them is not to be drawn into the conflict between the parents and not to take sides. Another one is to listen to what the child says, but not necessarily take as being the full picture from what the child says, because an alienated child may in fact construct for him or herself a distorted picture of the relationships in the family, or of the alienated parent, which, although may sound very convincing, and the child, him or herself, may be convinced that it's true, this may not be necessarily the case because of psychological split or because of the influence of the alienating parent on the child. This is one of the challenges, and that is in Israel, and I think in most countries, to make sure that if a referral is made, it's made to an appropriate person who is knowledgeable and competent and willing to handle these cases, which are in many cases highly charged emotionally. There is another aspect of prevention which actually comes from the court. Although many of my colleagues say that the family court is the last place to go for help when a family is in distress, and I agree with that, nevertheless, there are cases in which the intervention of the court may be essential because there is no other way in which to protect the interests of the child. Israel has a sophisticated system now for arranging for representation of a child by a lawyer who acts as guardian ad litem or as advocate for the child, depending on the age of the child. And this is an important tool in the armory of the judge, because such a lawyer who is experienced may be able to bring the parents to understand much better than their own lawyers what exactly the effects of the proceedings are on the child and what is liable to happen if the case is not resolved immediately. Also, we have developed in Israel a system which requires that where there's an allegation of abuse, including interference in contact between a child and a parent, the case has to be allocated to a judge, and the first hearing in the presence of the parties has to take place within 14 days. This is a directive of the President of the Supreme Court from a few months ago, and in addition, the fact that the case is referred to a specific judge who has full charge of the case in all its aspects leads to continuity of judicial management of the case, which is highly important, as we will see. The case comes before the judge. The parents have to be present. The judge will make an initial investigation of what the allegations are, and if the judge feels that there is a prima facie a case that one of the parents is interfering with contact with the other child, between the child and the other parent, even if contact has not yet been broken off completely, the court has a battery of orders that can be made. One is for appointment of an advocate or a guardian ad litem for the child. Another one is referral to a court-appointed expert who will investigate the situation and present a report to the court within 2 or 3 weeks as to whether the allegations of interference with contact have any basis. That expert will be entitled, of course, to see the parents and the child, and the court will add sanctions for non-compliance, so that if one of the parents fails to attend a session with the expert and or fails to bring the child, then it'll be made clear at the very outset that sanctions will be imposed for breach of the order of the court. After getting an initial report, the court can then refer the parents and the child to obtain help in reconciliation, reunification, if that is necessary. And it is very important to emphasize that the orders of the court are useless unless there are sanctions for non-compliance. In Israel, the courts have developed many different ways of imposing sanctions on a recalcitrant parent who is not complying with the orders of the court, including payment of money, including court costs, including a penalty, including a reduction in child maintenance payments, banning the recalcitrant parent from leaving the country, up to and including imprisonment for contempt of court for a short time. And the orders of the court and the decisions are reported in public. And this is the area in which prevention is effective, because a parent who is considering interfering with contact and sees a report in the newspaper that a parent was fined or sent to prison for failing to comply with orders of the court will think twice about failing to comply with orders about contact. There is, of course, much more to say. As I have told you, the challenges facing the Israeli system are to set up a sufficient number of experts in the field, and of course training of lawyers to recognize the signs of a possibility of a breach of contact. I'll be happy to answer questions, and anyone who is interested in doing so may contact me. My contact details are with the directors of this conference. I want to congratulate Marie-France and her team on setting up this conference. It is a matter of deep regret that because of COVID-19 and for other reasons I'm unable to attend in person, but I do look forward to corresponding with you, speaking to you electronically and meeting you as soon as it's possible. Thank you for your attention.